Thank you, Thomas, for agreeing to talk to us. It's such a pleasure to have a voice from WIPO, talk about perspectives and inform all our viewers about all of these perspectives. I'm thankful to Lohita and Creative First and the team for putting this discussion together. It's for our viewers. It's a pleasure to welcome Thomas Dillon, who's a legal counselor at the World Intellectual Property Organization, as you know, a UN organization. Thomas is a member of the English Bar, also admitted in California. He has worked at the WIPO at Geneva since 2014 as a legal counselor in building respect for the IP division, dealing with enforcement and awareness raising. From a background perspective, Thomas is a barrister, educated at the University of Cambridge, and he studied intellectual property law at Queen Mary College, London, and also has an MBA from the Sir John Cass Business School, City of London. Thomas comes with a lot of experience on ground, as we say, boots on the ground experience, being a member of the bar in England from 1984 he practiced at the bar till 2000, and then from 2010 to 2014. From 2001 to 2009, he worked in Brussels. Some would argue the nerve center for the EU, for the Motion Picture Association, becoming a vice president and deputy general counsel for the EMEA, in which he, as a part of which post he managed international anti-piracy cases and undertook policy work on IP issues. Thomas is also a fellow of the Chartered Institute of Arbitrators and a member of BAFTA. So Thomas, do you get to go to the BAFTA conferences, the award functions?
Well, I've never actually done it. I always think that I'll wait until I'm nominated. But I don't think that there's yet a BAFTA for anti-piracy services, but we can hope.
Let's hope this recording puts you in the running. So Thomas, I want to thank you again for taking our time. I know things are crazy across the world, increasingly so in our part of the world, and hopefully not in your part of the world as the days go by. So thank you for taking our time.
It's very kind of you, Ameet. I just want to thank you and Lohita and Creative First. I think it's a marvelous website that you have there, very well organized and very elegant. And it's a real pleasure and honor for me to be interviewed.
Thank you. A lot is known about the World everybody knows the World Intellectual Property Organization is the premier arm and of the UN dealing with intellectual property issues, an advisor of governments, a proponent of international treaties, and from which a lot of policy, prescriptions, guidance, and insight has emerged over the past few years. But I think people know these in generalities in terms of a general sort of awareness. And I think, you could do a lot to kind of help people understand, what WIPO does and your perspectives, given that we have this wonderful mix where you're concerned with actual experience on the ground as a barrister and in-house experience for associations, and now at the apex of what I call the apex of intellectual property, the WIPO. So, Thomas, could you tell us something about WIPO's important initiatives in building respect for copyright across the world?
Well, thank you. I'll try. It's true that WIPO is in a sense at the apex, but what people need to understand, I think, is that as an intergovernmental organization, WIPO is not a campaigning organization. Our mission certainly is to enhance the protection of intellectual property through international cooperation. That's what it says in the WIPO Treaty, set up the organization. But we are principally there as a forum to enable the international community to determine its rules. That's why treaty making is the core of WIPO. Now, that having been said, Of course, we do all sorts of things around that core activity. And in relation to respect for copyright, you have various bits of the organization that concern themselves with the subject. So we have a copyright law division, which is concerned about the treaties, essentially. They're concerned about the substantive law of copyright. And then we have a copyright development division, which is more concerned with helping developing countries to raise the level of protection. Then you have we have a large department which is concerned with administration of copyright. So they're helping countries develop the essential infrastructure, in particular in relation to collecting societies, which is less important for audiovisual, but it's very important for music and some print works. So we do all these things. And then in our little corner of this large organization, we have the Building Respect for IP division. And that is concerned with enforcement on the one hand and awareness on the other. So trying to help countries restrict the supply of infringing goods on the one hand, and then to reduce the demand on the other side. So in the past, the idea was enforcement, and this has kind of broadened over the last 20 years to Building Respect for IP, which has both of these aspects. And so our activity in the Building Respect for IP division, or the BRIP division, is focused on basically 4 activities. We have an assembly, we have a committee which meets every year or two called the Advisory Committee on Enforcement. And that is unusual among WIPO committees, and it has no normative capacity. As you know, enforcement is a very sensitive field because it rubber hits the road, basically. That's where it really matters. And countries have very different opinions about it. So rather than attempting to create treaties, this traditional modus operandi of WIPO, our committee is really for the development of discussion. And that's a very valuable so-called marketplace of ideas that helps countries to hear what other countries are doing and then develop their practices and policy. And then just very quickly, we give legislative advice. So that if a country is reforming its copyright law, our colleagues in the copyright law division will be asked to comment on the substantive provisions, term of protection, points of connection, all the rest of it. But we will be asked to comment on the enforcement bit. Injunctions, damages, and we also get to deal sometimes with issues of standing, which is quite important. And then finally, this is one of the things that I'm responsible for. We have an activity in helping member states create awareness. So we've developed a number of tools in that connection to help them. We also give them advice if they want it on developing strategies for raising awareness among the population, which is a tricky but important subject. So that in a rather large nutshell, so we say a coconut shell, is what WIPO does in this regard.
It's very interesting, Thomas. How does WIPO engage with member states? When it comes to the promotion and enforcement of copyright. I mean, is it WIPO being a UN body? Does it engage only with states? Does it engage with stakeholders? So how's that pattern?
Yeah, that's a very important question. I mean, our main clientele, if I can put it that way, is the copyright and intellectual property offices of the member states. Because as a public sector organization, we tend to be talking to other public sector bodies or other intergovernmental organizations because we cooperate with a lot of other IGOs. But we also do engage with industry to the extent they're willing to engage with us. I mean, we want to be in touch with what is going on in industry, because at the end of the day, that's the point. I mean, WIPO is actually unusual among, almost unique, I think, among UN agencies, in that it's largely self-funded. And it's funded because we are the custodians of a number of registration treaties. As you know, the Patent Cooperation Treaty, we have the Madrid system for trademarks, the Hague system for designs, the Lisbon system for geographical indication. And those are all money-raising activities, especially patents. So I think it's about, you see, it's probably 90% or more of the operating budget of WIPO is raised from industry, because we're assisting the private sector to acquire registered. Now, that doesn't apply, of course, in the copyright field, because it's not a registered right, at least not in terms of its kind of coming into being. But nonetheless, I at least, and in the enforcement, on the enforcement side, we're very conscious of the fact that it's happening in the real world. And so we're really very happy to speak to anybody about enforcement, as long as they understand that at the end of the day, the WIPO member states will call the shots.
Right. And you know, how do you assess how this you know, how has this cooperation with enforcement gone along you know, in the past few years? What do you think needs to be done, you know, kind of more? We now have treaties like the WIPO copyright treaties, which are amazing tools of harmonizing you know, copyright and respect for copyright and protection of copyright across the world. But you still have municipal laws which may or may not conform in a matter of interpretation, or from a letter of the law perspective to you know, treaty obligations. And so how do you assess this? You know, has this international copyright cooperation you know, gone along? What do you think? Rather, the main question, I think, is what more needs do you think needs to be done?
Well, obviously, I'm not authorized to express a view on behalf of WIPO's member states, or even and I wouldn't want to say anything about the substantive copyright law, because that's a matter for my colleagues in the copyright law division. But for me, from the enforcement perspective,
yeah.
I think that the area that's most important and interesting at the moment is the role of intermediaries. And we see in the European Union, for example, and I hasten to add that WIPO is not a European Union institution, it's a global institution. But in the European Union, you see with the 2019 directive on digital copyright, that there's a whole new effort to enhance or to reshape the position of large internet intermediaries in relation to copyright.
Right.
And we'll see how that plays out. I think on the enforcement side, of course, we do have a treaty, but it's not a WIPO treaty. Rather gallingly, it's a World Trade Organization treaty, the TRIPS agreement, the agreement on trade-related aspects of intellectual property rights. And when we're asked to comment on draft legislation, we take the TRIPS agreement as our measure, because it's the only international instrument that sets out in a comprehensive fashion all the basic tools of enforcement. And if you have all the tools that are set out in the TRIPS agreement in your law, and you're actually using them, then I think you have a pretty good regime. And so one of our functions is to help member states to implement the TRIPS agreement. Even though TRIPS is not a WIPO treaty, we have a formal agreement with the World Trade Organization that we will provide technical assistance based on TRIPS. So there is a kind of an institutional framework within which it happens. The provisions of TRIPS are discussed down the road in Geneva at the WTO and not with us. So very, very circuitous answer to your question. I think that the TRIPS agreement seems to provide an adequate guide for countries. They're free to go further if they want to. We always point out to them when they are proposing draft measures. We point out to them when they're going beyond TRIPS, because that is to go beyond their international application. But it's entirely a matter for them. And there has been innovation. I mean, we see now the most important innovation, I think, in the last 10 years has been site blocking injunctions. We see that have become increasingly normal at least in the common law world. And we see in India, of course, you've had a lot of judicial decisions, very bold ones, if I may say so, blocking infringements online. We see statutes, sophisticated statutes in Singapore or Australia that cover this. And I think that that probably is the most important change, and the successful one. I mean, we commissioned, well, we invited an economist to address our advisory committee a few years ago, Brett Danaher, on his research on the effectiveness of site blocking. And his figures are pretty clear that as long as your site blocking activity has a broad spectrum and you're blocking a large range of leading pirate sites, it not only reduces piracy, it fosters legal sales. So I think it's fair to say that there's a reasonable consensus now about the usefulness of this measure.
Right. And as you know, Thomas, as you just said, the Indian judiciary has been very innovative where site blocking injunctions have been concerned, and I'm personally very proud that my firm has played a leading role in that with my colleagues Sai Krishna Rajgopal, Siddharth Chopra, and Sneha Jain, etc., who all worked on these matters. And I think it was simply innovative of the judiciary to find a method to kind of deal with this very serious problem. We've gone beyond to dynamic injunctions and even dynamic plus injunctions, where courts have made it almost an administrative measure to add additional links and URLs and websites to the initial list that identified pirate websites. And how, in your view, how has site blocking worked around the world, Thomas? Because I see it's you have a site blocking body of jurisprudence in England. You had Justice Briss, and you had some amazing judgments, Justice Arnold, etc. And then you have Australia, which again is a place where another jurisdiction. So is it piecemeal? Do you see an evolving sort of international jurisprudence around site blocking really emerging now, or is it still at a level where it's too early to say?
Well, that's a very interesting question, Ameet, because the development of site blocking remedies has followed the legal tradition of each of the countries that have adopted them. And of course, some countries have not pursued site blocking yet, and they're under no obligation to do so. So it certainly can't be seen as a universal development. But I would say that most of the major economies, certainly in Europe, have a site blocking remedy. And that partly derives, but largely derives from the fact, of course, that there's a directive from 2001 that effectively requires them to have a site blocking jurisdiction. But how they do it is entirely a matter for the countries. And so, for example, in Germany, as you probably know, they already had a legal doctrine called disturbance liability, Störerhaftung, they call it. And they decided that was an implementation before the fact, as it were, of the directive. And so they used a Störerhaftung system, which does not give rise to liability and damages. It's a kind of a negligence liability, whereas in the UK, it's simply a non-liability based remedy, which is based on knowledge. And again, that's a national speciality. That's something that's been decided by them. So as long as they get to the goal that substantively they can block copyright infringing websites, then they've satisfied their obligation under the EU directive. But of course, in other countries where the directive doesn't apply, they go their own way. So I don't think that unless at some stage someone tried to say that it was a TRIPS violation not to have a site blocking regime, you won't see any international jurisprudence, I think, on that subject, right. Except to the extent, of course, that the European Union does have a border jurisprudence. But in principle, countries are free to approach the problem or not in entirely their own way.
Right. And taking the site blocking sort of principle forward, do you think it would be in the future perhaps more conducive to have an administrative framework for site blocking as opposed to the piecemeal judicial sort of intervention that we see, because judicial interventions can be patchy. They can be sometimes contradict earlier orders, etc. And are generally seen, from a doctrine perspective as being circumscribed by the facts in each case. And so from that perspective, you think it's conducive in the future for countries to consider moving to an administrative framework? Would that be a simpler, more balanced way of doing things?
Well, this is absolutely an area for member states to decide. And of course, different legal traditions have different approaches to administrative solutions. I mean, some countries of the common law tradition don't tend to have administrative solutions. We don't originally didn't have administrative law at all, really. But now, of course, it's very different. I mean, take Italy, for example. Italy has they are very satisfied with a site blocking regime that is operated by the telecommunications regulator.
Right.
The decisions are formal decisions made by the regulator. So they're administrative decisions. They're all published on a website. And then, like any other administrative decision, there's judicial review if you apply for it. As it happens, nobody ever applies for it because the decisions are not contested and they're absolutely defensible. So that's their approach. Then you get countries where you get a kind of a mix. So in the Russian Federation, for example, they have a very well elaborated system where the telecoms regulator is the moving force, but everything is validated through a decision of the Moscow City Court. And all the decisions of the Moscow City Court are published on that website. So if you're any good with Google Translate, you can read them. So that's a mix, and that's something that's been adopted in Lithuania as well. So, and then as you point out, you have the classic common law approach, which is the Indian approach, Australian approach, where it's happening in the court and only in the court. So I think each country has its own tradition, and it wouldn't be for WIPO to say which was the right way to go.
Yeah. Thomas, would you tell us something about the WIPO Alert project that you oversee?
Yes, well, with pleasure. WIPO Alert is a database, or a database of databases in a way. It's a secure platform that's operated by WIPO, and we invite member states to submit lists of websites that they have identified as being infringing. And the objective is to share that information with the advertising industry. Because you may know this, it's not a coincidence that I'm British, but the idea originated with the intellectual property police unit of the City of London Police, that they maintain a secure list of pirate websites and they share them with the advertising industry. And we thought at WIPO, well, this is a marvelous idea. Why couldn't we do this at the global level? Because there are people generating valuable information all over the world in their different systems. And surely this would be helpful on an entirely voluntary basis. It's important to say. Nobody's being forced to do anything. It's just a coordination exercise, which is within our jurisdiction as WIPO. So we have 11 member states at the moment in the system. We formally launched in 2019, I should say, and there's a document on the website relating to the Advisory Committee on Enforcement, which explains how the system works. And you can even watch me on video talking about it, which I don't recommend. But our kind of founder members, as it were Italy and the Republic of Korea, both of which have essentially administrative site blocking systems. And since then, we've been joined by Brazil, Spain, Japan, Peru, Russian Federation, Ecuador, Ukraine, Mexico, and most recently Lithuania. Now, we don't get data yet from all of them, but we get the data from a lot of them. And we have, at the moment, I think it's about 6,400 domains on the system. We have a similar number of users. We have not been as active or I suppose as effective in recruiting users. So I'm very grateful for the opportunity to publicize WIPO Alert, because it's a free service to advertisers or advertising agencies or technical intermediaries. We found that the constituency that's most interested in our data is those firms who provide services to the advertising industry. As you know, online advertising is fantastically complicated from a technical perspective. And there are specialist firms which help companies to target their advertising in the right place. And our system is potentially entirely automated. We have an API so that programmatic advertisers can plug into WIPO Alert. And before they buy advertising space on a specific website, they can their machines can call our machine and say, by the way, is this site a pirate site? And if it's a pirate site, then they don't load the ad.
Wow.
So it's a technical service to the international advertising industry that's basically supported by a group of member states. I could probably go on at great and confusing length about it. That's the essence of WIPO Alert.
I find that's very interesting. What do we do to get India on board?
Well, we've had discussions with the Indian government, with CPAM, at an early stage, and I was very heartened to see that the draft e-commerce strategy that was published was that February 2019.
Yes. Yes.
They explicitly endorsed the notion of a list of this sort. We're very well aware that India has several large film industries and a number of large film industries in different languages. And so, we will be very, very happy to be able to work with the authorities in Maharashtra, for example, or Telangana. It's complicated. Government is complicated. These are difficult times. But we continue to seek dialogue with member states in the hope that we can add to our member states. We've got Russia, Korea, Italy, Japan. These are very players. So we're very happy we've got off to a good start.
Because I think that a database like the WIPO's alert database is going to be fantastic as a guide for Indian courts as well, and to have, is there to understand the alert process or the project's process more, are there thresholds that you require from member states or due diligence processes that you require them or advise on before you get these websites onto your list, or you allow them onto your list?
That's another very interesting question. We don't dictate to member states.
Right, understandable.
But what we do say is that in the interest of transparency, we ask member states to explain in a public document their approach to listing. And we have that on the WIPO public website. Mm. The public cannot access WIPO Alert, it is secure. But we tell the world, and we're going to work on increasing the transparency with the search function we intend. But so it's all laid out. We obviously have to have some parameters for the structure of the intellectual structure of the system. So we say that member states can upload domains of sites of concern, which is a very broad concept, because we don't want to restrain member states with some technical definition. We know what we're talking about. We're talking about blatant pirate sites that deliberately infringing copyright. It's the pirate bay. That's the kind of talking about. But exactly how they define it, exactly how they decide to list them. So you might say, well, we'll list them if they have new content, or they have 70% of the content on the whatever it is. But as far as we're concerned, that's fine. It's for the member states.
It might interest you to know, Thomas, that Indian courts actually dealt with this issue of what kind of websites, are liable to be blocked, and they categorized pirate websites as rogue websites or vehicles of infringement or piracy, where you had a technical affidavit which assessed and which could be assessed by the court as well, to ensure that where the criteria was that an overwhelming percentage or a majority or a major percentile of above 70, 75%, 80% of the content on that website was pirated, unlicensed, yeah. And Indian courts now categorize them as vehicles or rogue websites or vehicles of infringement, and that was sort of a dispensation kind of which did not only go through a single judge that looked at this sort of a criteria yardstick, but went up to the division bench of two judges, which looked at this and approved of this process, on appeal by telecom service providers. So it was interesting to see that not only have Indian courts treated this as a good, effective tool to look at enforcement, but are mindful, of the need for balance to ensure that freedom of speech and expression, fair dealing or fair use aspects are respected, but at the same time, the objective of dealing with piracy, which is now a pain point, especially digital piracy, which is a tremendous pain point for the industry, is not looked at. I mean, just about a month ago, one of the biggest film releases by one of the biggest stars, because of the COVID-led lockdowns, had to be released on an OTT service. It was a pay-per-view, and the digital piracy around that one film, I think imperiled the entire production value of that film. And what people don't realize is the kind of lives lost, and these are not cliche terms. It really means that businesses suffer and they can't employ people. And after 25 years in the profession, I've realized that these are not cliches. These are genuine consequences that are visited on industry. And given the impact of lockdowns and the effect that the pandemic, the COVID pandemic has had, how do where do you see copyright enforcement? Do you see new dimensions emerging in, new tools, new strategies emerging on the copyright side, or are we just now focused on digital piracy and we just need to up our game on the digital piracy side?
Well, I think just before I can answering that directly, I'd just like to pick up on what you were saying about the need for balance, because we at WIPO, the work that we do is governed by what we call the WIPO development agenda. And that was a set of recommendations that were agreed by our member states in 2007, which require WIPO, among other things, to focus on the development aspect. So when it comes to enforcement, we absolutely embrace the notion of balance. We want balanced enforcement. We are not the copyright Taliban. We are there to help member states achieve balanced enforcement, and that's something that's expressed in the TRIPS agreement. And the reason why these issues about listing and site blocking and so forth are tricky is because you have to respect the rights of defense. That you have to, it has to be fair. Absolutely. Justice. They're not enforcers for industry. But nonetheless, at the end of the day, intellectual property rights are property. They are entitled to protection. And so what makes the area tricky but interesting is threading this path between enforcement, tough enforcement, and respect for the rights of society, freedom of speech, say, the rights of defense, and so forth. It's a tricky one. But in answer to a question about developments in which these considerations will undoubtedly continue to play a major part, I think that we will see more sophistication in the injunction regime, as you mentioned in India, have already embraced these ideas of semi-administrative injunctions. I'm also interested in the role of technology. I mean, I think that We already see some use, apparently, of artificial intelligence. The Korean Copyright Protection Agency uses, they say, a form of artificial intelligence when they're searching for pirate sites. I think, though, from a technical perspective, I think that the tools have been available to deal with copyright piracy for the last 15 years, probably. But the real problem is the institutional framework. You know, how do you frame the use of these tools in a way that respects all the values that we've been discussing? No doubt there will be new forms of piracy. I mean, the rise, even though downloading obviously is still very important, the rise of streaming, both on the legal side of the ledger and the illegal side of the ledger, has transformed the industry. So how we deal with that, I think, will be continue to be a major problem.
Right.
I mean, we could talk more about, you know, there are technical innovations, or more sophisticated watermarking, you know, but I think that the big problem that nobody's, I don't think, really solved at the moment is the sale of these generic streaming devices, which cause great concern to governments and right holders. It's difficult to formulate kind of an ex post legal remedy to try and reduce the use of those devices for piracy. Yeah, so I suppose the answer is, well, obviously I don't know what the future holds. I think that's a tricky one, and we haven't really, I think, reached even the outline of a solution for that yet.
You know, Thomas, the other day, I think a week ago, you had, you know, the major sort of services. You had Facebook, Google, a lot of social media outages, and all of them were not available, you know, for hours, and that led to some very interesting discussions. But you know, it struck me that website blocking on a jurisdictional piecemeal basis is going to deny perhaps revenue or the market of one jurisdiction to a pirate business, but it's going to let other, you know, perhaps other jurisdictions will take, you know, the sort of pressure and kind of will make up for the numbers. And I wondered if at some day we could come to a point, and I think the WIPO Alert project is perhaps, it's perhaps a node point, but I was wondering in the future if we could come to a point where we could have legal outages against pirate websites on a cross-jurisdictional basis at the same time. You know, when I was young and we did anti-piracy work, we timed ourselves across multiple locations to enter locations at the same time, and that had its own effect. And I've often wondered whether, you know, maybe it's wishful thinking, because I think coordinating or harmonizing this effort across multiple laws and different types of systems with different personalities and characteristics may be wishful thinking. But if you had a system of, you know, global legal outages against pirate websites, you could really then impact the financial efficacy of, you know, such businesses to really operate. And, you know, perhaps it doesn't really help. It becomes a game of whack-a-mole, doesn't it? You know, beyond a point of time. And you know, so what, you know, further or future initiatives can we look forward from WIPO in terms of, you know, promoting respect for copyright, or, you know, the benefits of copyright to society at large?
Well, we do, of course, we have, since I've been in charge of this, we've developed a number of tools, especially to try and get through to young people. We've developed a very nice animation on respect for copyright using the Pororo, the little penguin character, who's very big in Korea in the Far East, but known all around the place. And we've done that in 7 languages. We've got a website in English and Spanish on respect for copyright, which is used basically in schools. We have a number of awareness, we continue to make awareness videos, live action on respect for copyright. We've done one in Malawi, one in Trinidad. We're hoping when COVID permits us, we're going to do a Spanish language one in the Dominican Republic. We also have a very interesting project, which I'd like to see spread around, which we tried out for the first time in South Africa, of citizen journalism and intellectual property. So we go to schools, we spend a day with them, training them we have some outside consultants who are very good at this kind of thing. Train them about the nature of citizen journalism, using your smartphone to create journalistic pieces. And we teach them about intellectual property, respect for IP, copyright and trademarks at the same time. And then they integrate those two things. Now, that teaches them a number of important things about media literacy. And I think that it's a very good thing if copyright, which is all about actually the freedom to speak, I mean, to speak my speech and not to have it taken by someone else. So it's part, as the Supreme Court said in the States in the Ashcroft case, Eldon Ashcroft, you know, copyright incorporates free speech. So it's not the problem. Copyright is not the problem. Copyright is part of speech. And I think that encouraging young people to understand the role of copyright in journalism and in entertainment is something positive. So we're going to do this again in Senegal, French-speaking country, and we hope to spread this out. But I think on the more technical side, you asked about developments kind of at the global level. I mean, obviously I'm very keen on developing WIPO Alert. I would like to see us, I've floated the idea that maybe we could work with payment processors to help with the streaming piracy problem. That's just a thought at the moment. It may or may not be practical, I don't know. But one very important development which people need to be aware of, I think, in the legal community is the draft anti-piracy treaty, not anti-piracy, anti-cybercrime treaty that's under discussion in the United Nations. You know that already there is a cybercrime treaty, the Budapest Convention, which is a Council of Europe instrument. So although it has some non-European members, it's mainly European. A couple of years ago, it was proposed that there should be a global treaty on cybercrime, and copyright crime is part of cybercrime. That's something that I want to insist on. It's in the Budapest Treaty, it's explicit. Copyright piracy committed with the computer is cybercrime. And as you know, for those of us on the intellectual property side, cybercrime is a massive subject. It's very, very important for member states. Dare I say, more important than copyright. And so I think it's very important for copyright interests to help the world of policy understand the importance of copyright as part of the internet infrastructure, because copyright, in a sense, is the thing that's bought and sold in sort of information services, software services, all these things. So we are part of the debate about cybercrime. So I'm hoping that copyright interests will be aware of what's going on in the UN, and that they will, on whatever view they have, that they will engage with that process. And WIPO obviously is not the forum in which that is happening, but I'm sure we will monitor very closely what is going on there, because really, as I say, I think that if you've implemented the TRIPS agreement, and of course LDCs, least developed countries, have much more time; they don't have to do it immediately. But if you implement the TRIPS agreement, and it's done, as you say, internationally, if enforcement takes place at the international level, then I think you've got the tools you need. And the thing about the cybercrime treaty, like the Budapest Treaty, is it has a lot of bases for cross-border assistance, mutual legal assistance.
Right.
That's the trouble. It's not that we've got the tools within the national environment. It's just that when copyright piracy crosses borders, that's when it becomes difficult. So the more coordination that we can have through international instruments agreed by member states, then I think the better it will be for enforcement.
Oh, absolutely. And you raised a very interesting subject in terms of online payments and electronic payments. And I think there's something that I've been canvassing for years is for the Reserve Bank of India to amend what's known as this master circular on prepaid instruments and credit cards and debit cards and international debit cards, where already the bank disallows or prohibits payments for lotteries or gambling websites, etc., pornography, etc. And the argument is that given that copyright is recognized as a criminal offense and a civil wrong in India already, a prescription by a general prescription, just as is done for gambling sites. I mean, the RBI does not decide what is a gambling website or what is not. But in terms of prohibiting the use of these instruments for such services, will be an additional arsenal in the tool of copyright owners and affected parties and stakeholders in going to the RBI after, say, a judicial determination about, a list of websites, uh, uh, perhaps the alert list, to ask the RBI to prevent, and direct banks not to allow payments, electronic payments or remittances to such portals. And I think
yes, so I think it's important to say that certainly we are not proposing any kind of mandatory arrangement. WIPO alert is voluntary, entirely voluntary.
yes.
And nobody on our side is suggesting anyone should be forced to do anything, but we think there may be a demand for cooperation. If so, WIPO is there to coordinate and assist people in doing what they want to do.
Yes. No, absolutely.
You're asking for it to be mandatory, but
I know we have to choose our words carefully. And how do you think that the WIPO can play a leadership role, Thomas, in strengthening IP copyright policy? For instance, again, one of the things that I thought WIPO has this amazing study on the creative industries. It's done, I think, about 41 or 42 countries. And I've been for long saying that India needs to engage with WIPO on that study to have a measure of its creative sectors across the board. Now, we have piecemeal industry studies, but the WIPO study can really kind of break out, given the breadth and the scope of that study. So, in your view, how can WIPO play a leadership role in strengthening copyright policy and enforcement to help protect the interests of creative communities?
well, I mean, we do have an excellent economics and statistics division, which studies economic aspects of intellectual property. And the methodology for the copyright industry's studies is, of course, public, so anybody can implement that methodology if they want to. I think that so far as the leadership role is concerned, there I think I have to disappoint you, because I think it's not WIPO's function to push member states or lead member states in any particular direction. We want to facilitate their discussions, provide them with information, and enable them to do what they want to do within the freedoms that they have within their treaty obligations.
Yes.
Of course, for industry, it's important for industry to inform government, obviously, as to what its requirements are, and then government will make policy decisions. But we are, at the end of the day, WIPO is a diplomatic organization, where our 193 member states must have the upper hand.
Correct. And I hope, again, the creative study is something that the government of India looks at as being the authoritative sort of mode of then finally scoping, because I think a lot of policy making can be driven can be more robust and more targeted with and I think engagement with WIPO on a larger level, given its ability to kind of coalesce comparative perspectives from across the world, will greatly help in policy making. And I sincerely do hope that the government of India kind of looks at this more closely. I'm personally quite excited about your WIPO alert project, and I kind of want to look forward to how it kind of proceeds. And again, I hope India joins. This is something that organizations like MPA and other associations should certainly request the government to kind of look at actively. I think, given the pandemic world and given we are bound to be in this state for some time, unknown, a lot of cross-border cooperation is bound to become, perhaps important or critical in dealing with digital piracy. And I want to thank you, Thomas, for taking out valuable time and speaking with us. And thank you so much for your views. I know people who are going to watch this recording are going to be very interested, particularly with the Alert project. I'm really excited. I personally will also kind of watch out for the project. I hope it grows even more. So congratulations to you and your team again
Well,
on
thank you so
this
much.
amazing project. And thank you for talking to us, Thomas.
It's been a great pleasure. Thank you very much indeed.
Thank you.